Yeah. Hello? I don't even think this is on, is it? Okay. Sorry, I was too short for this stand. Okay. All right. Hi guys. I'm Brittany. I'm the Chief Justice of the Moot Court team here at WVU. We're so excited to have everyone here for our final round of the 10th energy competition. We have teams 20 and team 5, which are the University of North Dakota with Mr. Logan Caldwell and Miss Audra Fisher. And then we also have the University of Virginia with Mr. Jeremy Kemp, Mr. Demetrio. Oh, look at me. Okay. All right. And we also have our judges who are judging this final round. So we have Judge Lynch, who is from the Second Circuit, Judge Michael Alloy from the Northern District of West Virginia, Judge Faber from the Southern District of West Virginia, and Judge Trumbull from the Northern District of West Virginia. So we'll just get started with this argument in a couple moments, and good luck.
Oyez. All persons having business before this honorable court are admonished to draw near and give attention, for the court is now sitting. The case of Mammoth Pipeline LLC versus Citizens Against Pipelines will now be heard.
All right, please be seated, everyone. All right, we're here today on Consolidated Cases. I guess the caption starts with Mammoth Pipeline LLC against Vandalia Department of Environmental Conservation. So we'll hear first from counsel for Mammoth Pipeline.
Good afternoon, Your Honors, opposing counsel, and may it please the court. My name is Martha Amdahl. My co-counsel, Logan Caldwell, and I represent Mammoth Pipeline LLC in the 4 issues presented here today. Before I begin, I'd like to reserve 2 minutes of our time for rebuttal.
You may.
Thank you, Your Honor. Would the court like a brief summary of the facts in this case?
I think we're a hot bench. We're ready to hear your arguments.
Excellent. Thank you, Your Honor. I will be discussing Vandalia and West Vandalia's waiver of their rights to deny Section 401 certification under the Clean Water Act, and my co-counsel will discuss Mammoth's rights to the state-owned land in Franklin, as well as the Secretary of Agriculture's ability to grant rights-of-way over federal lands. Your Honors, consistency is key, particularly with all the uncertainty in the energy business. Companies like Mammoth need consistent rules and regulations in order to apply for Section 401 certification and do what they are supposed to do. Mammoth did just that. Section 401 of the Clean Water Act states that any applicant for a federal license for any activity which may result in discharge into navigable waters must first receive Section 401 certification in the controlling states. Mammoth attempted to receive Section 401 certification from the states of Vandalia and West Vandalia, and by failing to act within the statutory review period, Vandalia and West Vandalia waived their right to deny Section 401 certification.
Well, Mammoth had some role in that, didn't it? It submitted a very incomplete application to start out.
Yes, Your Honor, and upon Vandalia's request, Mammoth withdrew that application and submitted...
Didn't withdrawing it start the clock over again?
No, Your Honor. It was still the same application. It was the same pipeline, the same route of the pipeline in Vandalia. It was the same application with supplemented information.
Well, why should that not allow restart the clock? Because otherwise you could submit a poor application and then submit a much better one with very little time left on the clock and the state would have only a short amount of time to consider all of the information in that and all of the disclosures that might be made in the later supplemented application. Why would we want to allow that?
We want to allow that in this case, Your Honor, because it was the state that was acting in bad faith. It was Vandalia that waited
Now, what evidence do you have that the state acted in bad faith? That's strong.
Your Honor, the evidence is that if Vandalia's position is that the 18-page application was wholly insufficient, then Vandalia should have denied that application outright, not waited until...
Was there a time period that they were required to prior to the deadline of 1 year?
Your Honor, the language in the Clean Water Act states that states must act in a reasonable period of time. Now, the Clean Water Act does say that that reasonable period of time shall not exceed 1 year. But again, the core principle of the Clean Water Act is what's reasonable. And it is unreasonable to wait 363 days to review an 18-page
If I
application.
understand your argument, you're saying that the second request for additional information was really motivated by a desire to let the clock run out on this. Is that your position?
Yes, Your Honor.
How do we know that? What evidence is there in the record that goes to the motive of the request for the second?
Your Honor, page 5 of the record indicates that no pipeline projects, no Section 401 certifications in the state of Vandalia have been granted since Governor Rossi's appointing.
How many applications were there in that time period?
I apologize, Your Honor. The record is silent as to
So we don't actually know whether they denied any. Maybe you're the only application. I'm not sure what's persuasive about the fact that they haven't granted any application.
That's possible, Your Honor. However, again, the state did not act reasonably by waiting until the 11th hour to ask for additional information. And Mammoth complying. Did you have a question?
I do. Let's go back to the requesting additional information. Don't you think that 79 additional pages of information relating to the location and other certain specifics it dramatically alters the effect of the application in the first place?
Not necessarily, Your Honor. It is still the same pipeline, still the same application. There is additional information there, and Mammoth was more than willing to supply Vandalia with that information.
Well, there's 4 times as much information. It's not just more information. It goes from 18 pages to 79 more additional pages, right?
That's correct, Your Honor.
And what would be so wrong with the rules saying that the clock should start when they submitted the next application or they submitted additional information when it's such a significant change, not 1 page from 19 to 74 or 90 pages? What would be wrong with a rule like that?
What's wrong with a rule like that, Your Honor, is that we began engaging in a withdrawal and resubmit scheme that the D.C. Circuit saw in the case Hoopa Valley Tribe versus FERC.
Well, this is not even close, is it? I mean, that's 1 page. They're really gaming the system. Every year, 1 page.
And
I don't even think it compares.
And the application that was submitted was the same application year in and year out. The facts are not similar in this case.
Your Honors are both correct that the facts are distinguishable from Hoopa Valley and our case at bar. However, the holding that withdrawing and resubmitting the statutory review period does not restart the holding that withdrawing and resubmitting Section 401 applications does not reset the statutory review period still applies here.
Well, wait, the holding of what? This is the D.C. Circuit, right?
Yes, Your Honor.
We're the 12th Circuit.
Yes, Your Honor.
This is a case of first impression in this circuit.
That's correct,
So
Your
we're
Honor.
not bound by what the D.C. Circuit said at all.
No, Your Honor, that's correct.
Right.
It's
So we have to decide, in a sense, if we even agree with the D.C. Circuit's analysis, we still have to decide, like, what's the rule and what's the exception, right? How broadly is this exception that the D.C. Circuit found to be drawn? Right? So the question really stands, why should we set it here where this case is?
We should set it here where this case is, Your Honor, because Mammoth is acting in good faith and the state is not. Mammoth.
Well, again, you say that, but what is the evidence of the state acting in bad faith? As my colleague suggested, that's a very strong charge.
Your Honor, the evidence is in waiting until the 11th hour with the initial application statutory review period.
But if you say, well, we're in good faith. We submitted our 18 pages, and they could have denied it right away. You could have stood on that application and said, no, we're not going to submit anything new, right? And then they would have been forced, if they are so bound and determined not to let you have your permit, then they would have been forced to deny. And then you would have been able to have judicial review of whether that was a reasonable decision. But you didn't take that route, right? Well, why shouldn't we infer that the reason you didn't take that route is that you knew you'd lose because the 18-page application wasn't any good? So you took another shot. Is that not a reasonable inference for us to draw?
No, Your Honor, because respectively, there's no reason to suspect there is a problem until a problem presents itself.
Why should we ever let anything this significant and has such a huge impact on our environment get by on a waiver?
I'm sorry, Your Honor, could you ask that question again?
Yeah, I mean, you're asking this pipeline to go through based upon a waiver that they didn't act timely. And so there's serious environmental consequences to this. And so why should we let it take place on a waiver argument? As the judge indicated, you don't want to talk about the merits, you just want to talk about they didn't do something timely.
Your Honor, the reason we are not discussing the merits of the denial is because those are not up for discussion today.
You like it that way, right? Because you don't want to talk about the merits.
Yes, Your Honor.
Okay.
We are dealing with the...
I mean, look, you're entitled, of course, to stand on the record as it is and say, well, this is the way it played out, and these are the rules, and this is your argument. I understand that.
Mhm.
But that doesn't mean we have to go along with that and say, well, I mean, the question is, why should we let this? Why should we be so eager to have a waiver when there's a perfectly good argument that the clock should start again on the facts of this case? So that's what we have to focus on, I think.
Yes, Your Honor. And the reason that the waiver period should not start over in this case is because the additional information that Mammoth submitted was at the request of Vandalia. And had we chosen to not withdraw that application, then it would have taken much longer to go through the appeal process.
Well, now you're here doing the appeal process. I mean, how long did they wait the second time before they denied?
How long did Vandalia wait, Your
Yeah.
Honor? Approximately 10 to 11 months.
Okay, so they let the clock run. But then that's the most they get, right? Because now you did stand on the application as it was, and now you're here doing judicial review. But your only argument that you're making is the waiver. You're not challenging the decision that they ultimately did make to deny it. And you're not saying there was anything wrong with that decision. And that strikes me as problematic, no?
Well, Your Honor, it is the waiver. I'm sorry, Your Honor, could you ask that question again?
Yeah, well, the question is, I mean, you say, well, we can stand on the waiver. But the fact is, you had every right after they you didn't come in right away and ask us to start intervening in this case. You pursued the application, took a bite at the apple, submitted a really full application, and got told no. Then you appealed that. You had the right at that point to argue the merits, right? Is that not right?
Your Honor, in this case, the reason that Mammoth did supply that additional information was because Mammoth had no reason at the time to suspect that there was a delaying tactic or a scheme going on. And because Mammoth had that information readily available, the record states that Mammoth was able to supply Vandalia with that information within approximately 2 days of Vandalia's request. Mammoth was trying to work with Vandalia. Mammoth was trying to follow the rules. It was only until the second time that Vandalia requested for additional information without any...
Is there any reason that information wasn't provided with the initial request so that it would have been more complete than the 14 pages that was initially submitted?
I apologize, Your Honor. The record is silent as to why that information was not included in the initial
I'm just wondering
submission.
whether or not Mammoth was waiting a waiting game to see if the government would, in fact, not act on it so that there could be waiver, and in essence, submitting a flawed application in the first place was part of your motivation.
Not at all, Your Honor. Again, Mammoth is trying to follow the appropriate rules and procedures of both states involved here, in Vandalia and in West Vandalia.
There are four principal issues in this case, as I understand it. Are you charged with arguing any of those issues other than the waiver?
I'm discussing the waivers, Your Honor. My co-counsel will discuss the
Just the
following
waiver?
two issues.
Okay.
Yes, sir.
I wanted to make sure you had time to cover the rest of your argument, if there was a rest of your argument.
Yes, sir. Thank you. There is. In West Vandalia, Mammoth also sought Section 401 certification. And the application process was slightly more complicated in West Vandalia because in West Vandalia, we were dealing with not only the Clean Water Act, but also the Army Corps of Engineers and its regulation regarding Section 401 certification. And the regulation in question here is not worthy of our deference because the regulation is unambiguous in terms of who can determine the appropriate waiver period and review period for states when they receive Section 401 certification. That regulation in question provides that the district engineer shall determine when a pipeline company has submitted a valid request and has 60 days to review said request.
So you're not challenging that regulation at all, right? I mean, I've had a little trouble figuring out what is the interpretation, and maybe I should be asking the other side this, but I'll ask you for your view of it. What is the interpretation that either does or doesn't get our deference?
The interpretation, Your Honor, is the Army Corps of Engineers' interpretation of its own regulation.
Yes, but what?
Yes.
So who interpreted what that is relevant here that you think does not deserve our deference?
Yes, Your Honor. In West Vandalia, the Army Corps of Engineers determined that Mammoth's amended Section 401 request, which was submitted on July 2018, was the valid request, as opposed to Mammoth's January 2018 request.
Yes. So what? So you think that's incorrect as an interpretation of the substance of the regulation?
Yes, Your Honor, and it's contradictory to West Vandalia's typical practice. Page 5 of the record indicates that West Vandalia does not treat amended Section 401 certifications as new requests.
But it doesn't matter what West Vandalia thinks. We're asking what the federal government thinks through the Army Corps of Engineers. West Vandalia can treat this any way they want. That's a state. They have their sovereignty, they have their laws, they have their issues, some of which we've just canvassed. But this is about what the federal government acting through the Army Corps of Engineers can do. Right?
Yes, Your Honor.
Yeah.
Yes.
So what is West Vandalia's practice? Why is that relevant at all?
That's relevant because the Army Corps of Engineers and West Vandalia work together. They work conjunctively with Section 401 certifications. I see my time has expired. May I briefly conclude?
If you, yeah, just very briefly on that question.
We ask that you reverse Vandalia and West Vandalia's denials of Mammoth Section 401 certification. Thank you, Your Honors.
Thank you very much.
Thank you.
May it please the court, my name is Logan Caldwell, and on behalf of Mammoth, I will be addressing issues 3 and 4 in this case. The Natural Gas Act's delegation of the federal government's exemption to state sovereign immunity and the Department of Agriculture's granting of right-of-way across the Homestead Farm. There is a lot of uncertainty in the energy industry, and the questions before the court today are the exact reason why. Issues 3 and 4 are not questions of whether or not Mammoth broke the law, but whether we are now going to pull the rug out from underneath Mammoth after they have complied with the law and done everything that was asked of them. The Natural Gas Act's delegation of the federal government's exemption to state sovereign immunity is not unconstitutional.
Nobody's saying anybody broke any laws, are they? And you're not accused of anything, are you?
Your Honor, Mammoth has done everything that has been asked of it. There are no accusations that we have broken any laws.
Yeah, I know, I understand that. So why are you telling me that? You're saying, you're making a big point of nobody says we committed a crime or something. Well, nobody does. The question is whether you have certain powers or don't have those powers under the congressional statutes and under the Constitution, right?
Yes, Your Honor.
So you can do everything right, but if Congress did something wrong by delegating this to you, then you don't have the power to do what you tried to do. Isn't that correct?
Yes, Judge.
Okay,
And
so let's focus then on the question that is here, which is it constitutional did Congress delegate this power to you, and if they did, is that constitutional?
yes, Your Honor. The Natural Gas Act's delegation of the federal government's exemption to state sovereign immunity is not unconstitutional. The Supreme Court has never found it to be impermissive, nor have any circuit courts that have addressed
How's this
issue.
case different from Penn East, the Third Circuit's? Why shouldn't we follow the Third Circuit's lead and rule against you on this issue?
Your Honor, the Third Circuit very closely looked at the language of the Natural Gas Act and came to the conclusion that we're dealing with two separate powers in this case. The first is the federal government's eminent domain power, which is not at issue here, that can be given to private party. The second one is the delegation of the federal government's exemption, which is where the Third Circuit struggled a little bit. Now, they answered the case on the constitutional avoidance doctrine, stating that the language of the statute was not clear enough for them to do a full analysis on whether or not it is constitutional. Now, the language in the Natural Gas Act has been amended in 2017, and that language was not part of the analysis in Penn East.
And you think that's a significant enough distinction for us not to follow Penn East? Is that right?
Penn East in the Third Circuit laid out exactly why they struggled with this delegation without the language, which they said if delegation was possible, the language must be clear. And that comes...
First of all, can you just talk a little bit about the difference between abrogating state sovereign immunity in some particular and delegating the federal government's authority to sue the state? I'm unclear about that.
Yes, Your Honor. Abrogation is a blanket pre-authorization for any citizen to sue any state.
Well, why any citizen in any state? Congress could abrogate the state's sovereign immunity by saying, with respect to a particular category of claims, private citizens can file suits against the state. And they do that, for example, with certain civil rights statutes. Congress has that power under Section 5 of the 14th Amendment.
The Fitzpatrick case. That is the only time that the Supreme Court has said that this abrogation can be used. It cannot be used under...
Right. So if abrogation is such a narrow doctrine in itself, isn't this idea that the federal government is delegating its own power to sue the state, doesn't that create a kind of loophole where Congress could just say, well, we could sue the state if we passed a law that says the state must do this or that, but we're not going to do that. We're going to pass a law that says the state can't do this or that, but private people can have our power to file suit. Why would we want to allow that kind of workaround just by giving a different label to it?
There's two different reasons. The delegation in the Natural Gas Act is exceedingly narrow, as opposed to the abrogation's blanket pre-authorization, as you mentioned in Section 5 of the 14th Amendment.
So why should we get any comfort by how narrow it is?
Because there's the political accountability aspect. In order to gain this Natural Gas Act delegation, you are directly overseen by the executive branch and the regulators and specialists in this area. There's extensive permitting processes, energy assessments, financial reports, working with state and local agencies. And then if and only if all of those criteria are met, is a one-time delegation given to a specific company to effectuate eminent domain against a specific state for only the land use. There's no monetary...
I'm maybe missing something. I thought there was a sort of blanket rule that you're advocating that anybody who's got a pipeline is entitled to eminent domain. Now, maybe there's all this permitting to decide whether they can put in the pipeline at all, but once they do that, can't they condemn any property anywhere along the way?
Only if three conditions are met: if the land is over $3,000, if they're unable to acquire it by contract, and if they have that FERC certificate.
But no one at FERC is saying, we're going to review whether you really need to condemn this particular state land, are they?
They are reviewing the pipeline as a whole to see
So
how it is.
they approve the route.
Yes,
so
Your
when
Honor.
they do that, they must know, is this your, they must know that it's
Generally.
going to go across this state land.
Yes, Your Honor.
Okay.
Yeah, and the language in the Natural Gas Act gives that very clear distinction. The Blatchford case from the Supreme Court also dealt with the idea of delegation. Now, while it was under a jurisdictional element, the court was very careful to lie out instructive dicta to this court and all others on how to handle delegation issues. And Justice Scalia, writing for the majority, said in there that the language must be clear. It must be unmistakably clear that a delegation is occurring.
Okay, so can you tell me where exactly there is language that references delegation in the statutes that we're dealing with?
It's page 8, paragraph 2 in the record, Your Honor, the block quote there, speaks that if that land that is going to be effectuated under eminent domain is a wildlife refuge as established under state or local law owned prior to 1992, Congress was not going to authorize eminent domain in that case.
So this is the interesting thing about this amendment is this is a prohibitory amendment. It says things that you can't do.
The first part of that does, Your Honor.
Yes, and the second part also says you can't do it without a public hearing. Now, I grant you that implies that you have such a right, yes?
It more than implies it, Your Honor. There is no other way to read this statute other than Congress intentionally saying that
But
state land.
this is a funny way to say we are delegating our eminent domain power to these organizations when what they're saying is it's acting like somehow they're already doing this and we're going to stop it or limit it to particular circumstances. That doesn't sound, and if what you wanted to say was, from now on, pipeline companies have this right of eminent domain, we're delegating that to them in this particular circumstance, right?
That is the unmistakably clear language that's under the abrogation standpoint. The Muth case from the Supreme Court states where they looked at the Education of the Handicapped Act, again, that was under Section 5 of the 14th Amendment, that sovereign immunity is abrogated, and they spelled out exactly what they were doing. But that is, again, under the very narrow and very strict way to give an abrogation, which is the blanket pre-authorization.
Oh, but I thought you told me already that the standard we should use for delegation is it explicit?
That is the turnaround that the courts that have looked at this case have clung to, which is that of abrogation, since it is most similar, with the exception that this is extremely narrow, a one-time delegation for land.
So the only time that there can be a condemnation of state lands is if it is a public park and there is a hearing. But any other state land, you couldn't.
No, Your Honor. The language of the statute says impliedly that there is an authorization for eminent domain. Congress gave all of its cards of eminent domain.
So really you're saying it must have done this in the earlier statute, right? It's not the amendment. The amendment is sort of post-enactment legislative history that suggests what Congress meant or must have meant the first time.
Yes, Your Honor, and that's correct for two reasons. One, in the original language of the Natural Gas Act, there is some legislative history that says that they were concerned that states would gain veto rights over public infrastructure projects if this were not allowed. A year after the Blatchford decision came, where again the court struggled with the idea of delegation, is when the Federal Powers Act was amended that had this language that is now adopted into the Natural Gas Act.
Why shouldn't we demand absolute clarity when we're talking about giving someone, a private entity, sovereign immunity or exemption?
This is a very narrow grant of
You're saying
the
it's narrow,
delegation.
but these lines are there forever. I mean, it's not a one-time thing that goes away.
It also presupposes that there would be a lot of battles against this state-owned land. Most states would be okay with it coming across so long as it was acquired the right way, and that there is a lot of state-owned land.
What evidence do you have that most states would?
Your Honor?
What evidence do you have that most states are happy about these big pipelines going across?
Well, congressionally authorized public infrastructure projects and having energy infrastructure throughout the state, or throughout the country, is something that benefits all of us. And is something
That's water lines and sewage lines, not 42-inch gas lines. That's not turning the lights on in my house.
The energy and electricity that could be supplied from this natural gas benefits all citizens in the states in which it goes through.
How? West Vandalia, how? What house is it warming? It's going down to Franklin, maybe across the ocean.
At the plan of the conventions, the several states came together and they gave a couple of things and they retained a few things. One of the things that they gave was the ability to be sued by sister states and to be sued by the federal government. This is similar to a key tam suit where somebody
But the federal government, if the federal government were actually bringing the suit, and it would be perfectly, if Congress wanted to do this, they certainly could say some federal agency can bring a lawsuit to condemn the state's property. And then if the federal government did that, they do it at the risk of the next administration, of that administration losing the next election, at least in that state, if the people didn't like the way the federal government exercised this power. But once it's delegated to some private company, there's no accountability anymore to who condemned this land? Was it the President of the United States that I'm running against? No, I'm afraid it wasn't. It was Mammoth Pipeline Company, and Congress gave them that power, so we have nothing to say about it anymore.
I agree with you, Your Honor, that there has to be follow-up accountability. This is why it's different than an abrogation. This delegation requires them to continually report to FERC with follow-up reports, annual reports, which gives that post-report. And if FERC is acting in a way that the public does not like, there is that political accountability of the next election cycle in the executive branch. But this is not the only issue of land before the court. Once again, we're dealing with the homestead farm and
Yes.
Mammoth
You
acting.
addressed that. Thank you. I'm glad you brought that up.
Mammoth acting appropriately and asking the Department of Agriculture for right-of-way to use the easement that it holds. Now, the standard of review in this case is going to be arbitrary and capricious. That comes out of the Fourth Circuit cow pasture case, cert granted. It is different than the facts in that case, but the analysis that the Fourth Circuit used should be used here as well. So in the cow pasture case, we have land that was given to the Department of the Interior, then delegated out to the Department of Agriculture. While they asked the Department of Agriculture for permission to use the land that they stood on was congressionally given to the Department of Interior. What we have here is land that was owned by a 501c3, and the conservation easement is held by the Department of Agriculture. There is no congressional authorization for the homestead farm. While it was considered—
So is that federal land at all?
It is federal land, and it's conceded in the record that the U.S. Department of Agriculture agrees that this is federal land.
Well, they may agree. We don't necessarily have to. I'm wondering why you have to get anybody's permission from the federal government at all in this case. It's the land that you are running your pipeline under belongs to this private charitable trust. Have they authorized this?
They have, Your Honor.
So then why aren't we done? I mean, that's
Your
not a
Honor,
hostile
we would
question,
submit that
but-
we are done there.
Yeah.
However, since my colleagues will likely get up and argue that we are very much not done there,
So then, so why is it federal land at all then? I guess I should be asking
it's
them
federal
now,
land
not-
because the easement is held by the federal government,
see.
and so because of that conservation easement, you must ask. I see my time has expired. May I
Yeah,
briefly
finish the
answer?
sentence, yeah.
Because that conservation easement is held, you must ask the Department of Agriculture, and the Department of Agriculture under the Mineral Leasing Act is the only agency that has jurisdiction over that land, which is the requirement term. The Department of Interior has no jurisdiction, therefore is not the appropriate agency to ask. Thank you.
Thank you very much. Now we'll hear from your adversaries, or at least one of your adversaries, which is we're Citizens Against Pipelines.
Yes, Your Honor.
I guess you don't like any pipelines. And you certainly don't like this one, so tell us
Our
what.
clients certainly do not, Your Honor.
Okay.
May it please the court, my name is Tyler Demetrio, and as you just mentioned, I represent Citizens Against Pipelines, and we have not reserved any rebuttal time. I plan to discuss Vandalia and West Vandalia's timely and merited denials of Mammoth's Clean Water Section 401 certification requests, and my partner will discuss the orders of condemnation in Franklin and the right-of-way across the Homestead Farm. This court should uphold both Vandalia and West Vandalia's denials of Mammoth's permit requests because in both cases, the state had a timely denial and had merits for such a denial. First, in Vandalia—
What was the basis for their denial on the second submission?
In West Vandalia, Your Honor?
Yes.
The basis for the denial was based on the Army Corps of Engineers interpretation that the state had 1 year from the amended
All right,
date.
what was the basis in the Vandalia case?
In the Vandalia case?
Yes.
The basis for the denial was that the Mammoth had the time period reset when Mammoth withdrew and resubmitted their application. And so then the state had 1 year to make a determination as to whether they would accept or deny the permit. And so I'll just jump right into the argument in Vandalia in the interest of time. So once an application is withdrawn, as was the case here with Mammoth, that application ceases to exist. There is nothing for the state agency to review during that time frame after which the application has been withdrawn. So an alternative rule by this court would lead to the illogical result that the clock is running while there's nothing in front of the state for them to actually evaluate. And this case is distinguishable from the Hoopa Valley case in the DC Circuit that opposing counsel raises, as you all have pointed out, in several clear ways. In that case, we had a scheme between the state agencies and the permit applicant to withdraw and refile the exact same one-page request year in and year out for over a decade. And we simply don't have that in this case. In this case, we have an incomplete application, an 18-page application, missing entirely information on wetland and stream crossings that would be critical to determine.
How was the last submission incomplete? Wasn't the second submission virtually the same as the last submission?
I'm sorry, Your Honor, you're speaking of the second submission being the 97-page
Right, yeah,
updated application.
when the government went back and asked for additional information the second time.
So, Your Honor, what we would argue as Citizens Against Pipelines is that the clock reset upon the first submission being withdrawn. And so at that point, the state had 1 year to determine their evaluation of the second.
Right, but then at the end of this, when they finally get around, after letting the clock run almost to the 11th hour and 59th minute, they didn't just deny it on the merits right away. They asked for more information, didn't they?
They did, Your Honor, as we would contend is within their right to do so.
So where is this ever going to stop? I mean, doesn't this give some support to Mammoth's argument that this is kind of a scheme? Whatever they submitted in the first place, maybe the first one was a little shoddy. They could have denied it and said, this is shoddy. We're not going to grant it on this record. You haven't disclosed this information. You haven't disclosed that information. Denied. And then if they wanted to appeal, they could appeal. If they wanted to submit a new application, they could submit a new application. But instead you say, well, let's string this out a little longer. We're not going to deny it. We're just going to ask you for more information. And they say, well, okay.
And the last submission was not materially different from the second one, was it?
Your Honor, I believe there are only two submissions. The second one being materially different from the first.
Well, I thought they had gone back twice and asked for additional information. Did they not?
They did go back the second time, and Mammoth did not provide that information. So there was never a third submission.
So the second time they eventually deny it.
Correct.
But they deny it after trying once again to spring out the clock, maybe let another 11 months go by. This does not smack of good faith, right?
Your Honor, we would argue that assuming the state, the clock did reset upon the withdraw and resubmit, the state again had 1 year to decide. Mammoth isn't bringing this case on the merits. They're contending that the 1 year waiver period ran. That's simply not the case here. What this court does have an opportunity to do is to create a rule.
Well, you said this is distinguishable from the Hooper Valley case, but I'm not sure I understand why it's distinguishable in the relevant respect, which is your argument would apply just as well in Hooper Valley, that each time there was a withdrawal, that ends, then there's nothing pending until 10 seconds later when the new one comes in.
Your Honor, this court has an opportunity to draw a line that threads the needle between Hooper Valley and this case, in our opinion. And that line is actually alluded to in the Hooper Valley opinion, in which, and I quote, they said, "We need not determine how different a request must be to constitute a new request such that it restarts the 1 year clock." And so the Hooper Valley court, which obviously is not binding on this court, did contemplate the possibility that a substantive enough change in a withdrawn and resubmitted application could restart the 1 year clock. And what we would argue is here is in the case of the withdrawn first application, there were substantive changes 5 times the amount of information included, additional maps and exhibits related to wetland and stream crossings, a critical concern.
I think the component that I'm struggling with is the fact that, you waited practically a year to deny the first application that you're claiming is woefully insufficient and required additional information. Once you got the new information within 2 days of the withdrawal of the first, you got 97 pages, substantially more information, and then again you waited 10 or 11 months before you took any action on that. So, the delay seems to be a scheme where if we just string them out, and then ask them to withdraw it, it's going to start the clock again. And I haven't heard justification for why it takes so long to make that determination in the first place. How many, and as it relates to your particular state, how many of these applications have been approved in the last 3 years?
Your Honor, and again, as the intervener, we're representing Citizens Against Pipelines and not the state, so it's a little difficult for us to speak to some of those determinations, as well as the absences in the record that opposing counsel's already alluded to. We don't have a whole lot about how many permits there's been per year or anything like that. It is true that the state has not accepted a 401 request since 2017, but as far as we know, this may be the only request. The record's just unclear on that point. But turning to West Vandalia likewise did not waive their Section 401 authority before rejecting Mammoth's application. I want to make a key distinction in terms of what interpretation that we're actually talking about here, Your Honor. And that is that the question here is whether the term valid, so the Army Corps of Engineers has a regulation that adds the word valid to its interpretation of Section 401, which just states a request for certification. And so here we had an initial application in January in which Mammoth submitted an application, and then an amended application 6 months later that changed the pipeline route. And so the question is whether the change in the pipeline route invalidated the initial application such that only the July application is a valid application for the purposes of running the one-year clock. And so here this court should defer to that agency's interpretation for two reasons. First, it passes the Supreme Court's five-part test articulated in Kaiser for granting our deference, in which this court must defer to the agency's interpretation. But even if this court finds that our deference isn't merited, it still presents strong persuasive authority for this court to rule in favor of West Vandalia and Citizens Against Pipelines, and that the 1 year started on the amended date. And so I don't have time.
Don't you have also the same, I don't understand what's the difference between your argument here and your argument about the other state's action. Because what happened here, it seems to me, whether there's a formal withdrawal or not, what happens is first there's an application, and then there's a amended or superseding or new, I don't care what label you put on it, an application that says a different route. And once there's an application for a different route, why, again, my concern with the other side on both issues is you let it go for a while, and then suddenly at a certain point you spring something new on the state. Why shouldn't that just start the clock again? Why isn't the Army Corps of Engineers just right, whether you give them any deference or not?
Your Honor,
or I guess you would
I
say there are,
suppose
right?
They certainly are. They
So-
certainly are correct. And please, if you don't want to go through the hoops of the five-part Kaiser test,
Well, but I have
certainly-
another problem though with the regulation. The regulation says it's the district engineer who's supposed to sign off. The district engineer didn't sign off, so why aren't you just down the tubes as far as the Army Corps of Engineers is concerned?
That's a great point, Your Honor. The reason is that, and while the plain
I'm glad
language
you
of
like
the
it.
regulation does say the district engineer, there's actually a sister regulation, CFR section 325.8, that allows for certain certification requests in the Army Corps of Engineers, including those under section 404, to be, under certain circumstances, referred up to the division. And so Colonel Foley here is a regional program director operating at the division level. I will admit we don't have, based on the record, whether this sort of communication happened between the district engineer and Colonel Foley.
Well, but I guess what I'm on, is he higher up or lower down in the hierarchy? than
He
the
is
district
higher up in the
engineer?
hierarchy.
He's higher up than the
The
district
division is
engineer.
higher than the district. The district is the smallest unit of the Army Corps of Engineers. The divisions manage multiple districts. And so his interpretation, I'm sorry, the request here, he had to get it somehow. You know, as a regional program director, he's not just having 404 requests come across his desk. So we would infer that someone from the district must have sent it up to the division level in this case. But to be fair, that is not
So the
specifically
more,
in the
well,
record.
but also, I guess you'd argue the higher up has more power than the lower down. It would be odd to say that there's some problem because somebody usurped authority under this when it's the person who supervises the person in the regulation. Is that the point?
Absolutely, Your Honor. And that gets to one key part of the Kaiser test, and that is this has to represent the agency's official interpretation of its own regulation. And here we have a high-ranking official, a colonel in the Army Corps of Engineers, acting at the divisional level, making a decision, publishing it in the Federal Register. It clearly meets the prong of the Kaiser test for it representing an official interpretation. But I also want to touch a couple of the other key points of the Kaiser test that we need to meet here. One being that the interpretation must be reasonable. The Army Corps' interpretation of its own regulation must be reasonable. And here, contending that a pipeline route change renders the initial application invalid such that only the new application is valid is entirely reasonable, and for that we can look to the substantive grounds on which West Vandalia denied ultimately the permit request. So
Well, that might be right as an interpretation of what valid means, but maybe we should go one step back. You said earlier that the Army Corps of Engineers put the word valid in. Maybe it goes a little bit beyond your mandate, but I was just curious under Chevron, is that a valid regulation to put in an extra word?
It certainly does need to meet Chevron deference here, Your Honor. And so we would argue that it does. So under Chevron, the interpretation of the statute of 401, it has to be an ambiguous statute, and it has to be a reasonable interpretation. So we would argue it's ambiguous and that it doesn't say, what kind of request is sufficient. You might imply that just a blank sheet of paper or a...
Okay, fair enough. And then assuming that I agree with that, then what would the standard be that we would apply? I mean, I'll grant you that you have a pretty good argument that the original thing gets withdrawn or changed when some new application comes in. But what would we be saying is the meaning of valid in this interpretation? It's a little unclear to me. Suppose, for example, that with respect to the other application in the other state, the Army Corps of Engineers had said, oh, that first one isn't valid because it's only 18 pages. Is that something that they have the authority to do?
Well, Your Honor, I will point out that that's a point in favor of the Kaiser prong, that this is an ambiguous word, the word valid, so it certainly passes the ambiguity portion of that test.
West Vandalia did not treat, isn't it true that West Vandalia did not treat amended 401 requests to restart the clock?
That is true, Your Honor, but we're dealing with
And so
an
wasn't
Army
that what
Corps...
happened here? There was a modification request, so from a consistency standpoint, wouldn't you follow the same rule that was in place before, or what they had done in the past as precedent?
We would argue that we would defer to the Army Corps' expertise here. As another one of Your Honors pointed out, there's a distinction between the state making a decision on its own on 401 and the Army Corps coming in under its Section 404 authority and making a determination. And here that interpretation is reasonable based on those three substantive grounds I alluded to. West Vandalia, when it ultimately denied the application, said there was an incomplete Endangered Species Act Section 7 evaluation. Those additional deep water areas that were created that exceeded the dissolved oxygen acceptable levels for the state. And there was no plans for wetland and stream crossings. Any of those three changes could be implicated by a change in the pipeline route. And so it's certainly reasonable here for the Army Corps to look at this pipeline route change. Again, we don't know. We need to finish and briefly conclude.
You finish your thought.
We don't know enough about the change in the pipeline route to know for sure, but those are certainly possible. And so for those reasons, we respectfully request that this court uphold Vandalia and West Vandalia's denials of Mammoth's water quality certification requests. Thank you.
Thank you very much.
Good afternoon, and may it please the court. My name is Jeremy Kemp, co-counsel for Citizens Against Pipelines. As my partner mentioned, I'll be handling the remaining two actions consolidated into today's appeal, those pertaining to the condemnation orders against Franklin's charitable trust property, and those pertaining to the Secretary of Agriculture's improper grant of a right-of-way for Mammoth's pipeline to cross the conservation easement on Homestead Farm, right within the viewshed of the National Scenic Trail, the Shandalia Trail. First, the district court did err in determining that a private company such as Mammoth has the authority to condemn land belonging to a sovereign state like Franklin. Now, this is true for two independently dispositive reasons. First, our opponents would say that this is at its core a question of really energy policy and consistency, but we assert that at least on this particular issue, it's about something even bigger. Only the federal government has the authority to compel a non-consenting state to appear in federal court, and that power is non-delegable. State sovereignty is really a core feature of American constitutional federalism. It says that any power that was not conceded to the federal government at the time of the Constitutional Convention is reserved with the sovereigns of the states.
Well, I notice you're jumping to the constitutional question. Is your second dispositive independent reason the statute?
Yes, Your Honor.
There isn't a delegation? How come you're not talking about that first? It sounds like you're not very confident in that argument, If you're leaping right to this is unconstitutional, do we have to face that if you're right on the other issue?
Absolutely, Your Honor. It is true that potentially, the statutory reason could have been argued first. We didn't order them for any particular
Well,
reason.
why don't you take up the statute then? Because if you win on the statute, we can avoid the constitutional issue and not take on the rather awesome responsibility of telling Congress what it can and can't do.
Absolutely, Your Honor. I'm happy to deal with the statute first. If we look to Section 7 of the Natural Gas Act, it does explicitly grant that the power of eminent domain belonging to the federal government can be delegated to a private party. The problem is that, as the court in Penny's described and as opposing counsel mentioned, there are actually two separate powers at play that are acting as a function of each other in order for a private party to be able to condemn a state's land. And those are the issues, the powers of eminent domain and the power of the federal government to abrogate a state's sovereign immunity.
So put another way, the eminent domain power is general. And Congress says Mammoth can condemn private people's property, and then that happens by them going into court and doing the things they need to do. But it's a separate problem whether they can delegate the ability to do the same thing against the state.
Absolutely, Your Honor. Absolutely, Your Honor. And indeed, if we look to cases in which the federal government has been dealing with a direct abrogation itself, again, not delegating to a private party, the standard that the Supreme Court has articulated in Atascadero State Hospital v. Scanlon is that that abrogation has to be unmistakably clear in the language of the statute. That means that...
But Mr. Caldwell argued to us that a delegation is different from an abrogation. Why should we apply the same standard to a different concept?
Your Honor, we believe that, if anything, a standard should be higher when the party that is doing the condemnation of the sovereign state's land is a party that doesn't have political accountability in the same way of the federal government. Opposing counsel cites that there are a variety of mechanisms by which the federal government can have some oversight over the finances and route and potentially some maintenance issues on the pipeline. But that oversight does not create the same level of democratic accountability as the federal government acting directly. And so we would contend that if there is to be a different standard applied to the delegation as opposed to the federal government's direct abrogation, if anything, given that there's more fraught constitutional problems involved, the standard should be higher. And again, we see in Atascadero State Hospital that has to be a textual standard, unmistakably clear. And while opposing counsel does point out that the 2017 amendments to the Natural Gas Act create a strong inference that there are some types of, that because there are some types of state lands that are named to be non-jurisdictional for condemnation in the statute, that may create a strong statutory inference that there are other types of state lands that are jurisdictional.
Well, yes, and didn't Congress obviously think that it had delegated the authority back in the original act, because now they're actually limiting that authority. And they're limiting it in very particular ways. This is a pretty narrow exception. It would say pretty much any state land, there's no problem with there being a condemnation, except for basically parkland. And as to that, there are certain specific procedural requirements that are imposed. So why would we not think that, defer to Congress's interpretation of its own prior enactment?
So, Your Honor, I think that actually really what's at issue here is going to bring me into the other dispositive reason, which is that Congress, even if it had been extremely explicit in the statute and had used the words abrogation or delegation rather, that doesn't matter because Article 1 doesn't get to define the outer contours of its limits within the separation of powers framework. That's a duty that lies with Article 3 courts. And indeed, when we look to what the Supreme Court has said on this issue that, again, relates directly to the structure and meaning of American constitutional federalism, we see that in the Supreme Court's case, Blatchford v. Native Village of No Attack, the Supreme Court pretty unambiguously cast doubt on their belief that this power, this really, really incredibly important power of the federal government to override a state sovereign immunity, they doubted that that power even could be delegated. And while it's certainly the case that that was not the holding here, or rather in Blatchford, if that was the case, then this wouldn't be an issue in this instance. At the very least, it gives quite a clear picture of where the Supreme Court is thinking and what direction they're going in terms of that delegability if they were ever to be in a position where they had to make that in the holding.
Well, it's our job to sort of guess at what the Supreme Court is thinking. We've got what the Supreme Court has said, which is we have our doubts, and maybe someday we'll have to decide that issue. Well, that day hasn't arisen in the Supreme Court, but it's here now for us. So we have to decide whether it is or is not the case that Congress can delegate this. And I'm not sure that the fact that the Supreme Court had a doubt in dictum answers the question. Were they right to have a doubt? Were they right to, should they have gone further, or should we go further? That's the question.
We would assert that you should go further. And to be clear, we're not asserting that Blatchford is in any way controlling on this court. We're simply asserting that it should be viewed as persuasive authority, just like the Third Circuit's application of that same
Yeah,
dictum.
but it's not exactly persuasive authority because they didn't actually decide anything. They said, that's an interesting question. We have our doubts. Good for them that they have doubts, but we can't have doubts. We can't say we're just like the Supreme Court. We have doubts. We have to decide the actual question now. So tell me why this is non-delegable.
Well, Your Honor, we would say that at the very minimum, compared to a situation in which the Supreme Court had never, in any situation, holding or dictum or anything of that nature, if they had never spoken to this issue, then we would argue that there would maybe be a less strong case for the point that we're trying to make here. And so all we're saying is that the fact that they have said that, it should at least point in the direction that this court should view that power to be non-delegable. And additionally, sister circuits such to this court have already applied that same dictum in a case bearing a remarkably strong factual similarity to the case at hand. And the Third Circuit in Re Penn East Pipeline found that a pipeline company that was a holder of a certificate of public convenience and necessity from FERC could not condemn the land belonging to the state of New Jersey, 42 parcels of land belonging to the state of New Jersey along that pipeline company's desired right-of-way. And so again, certainly the Third Circuit's decision here is not something that is binding on this court in any way, shape, or fashion, but it should still nonetheless be viewed as strong persuasive authority for the conclusion that that power is non-delegable.
But you're still not telling me why they're right. I mean, what is it about their logic that that should persuade us? I grant you they've said that, but as I said to your adversaries, this is a case of first impression in the 12th Circuit. In fact, as far as I'm aware, every issue is an issue of first impression in the 12th Circuit. I don't think we've got any. This is our first case, as far as I know. So tell me why, what is it that's so significant about this power that it should be non-delegable?
Your Honor, we did certainly struggle to find case law for the 12th Circuit, but nonetheless, what we really believe is the issue here is state sovereignty at its core, and that's really should be the animating consideration for this court, at least on this particular issue. And given those authorities, the Third Circuit deciding a very similar case and the Supreme Court casting doubt in dictum, we believe that combined with just the inherent reasons of state sovereignty and the arguments that we've presented in terms of the value of preserving that sovereignty truly, we believe that should be sufficient for this court to hold that power non-delegable.
But could you address the other issue then about the Department of Agriculture versus the Department of the Interior?
I was on my way there right now, Your Honor. We believe that the Secretary of Agriculture did not have the authority to grant the easement across the conservation easement on Homestead Farm. And the core issue here is whether the National Trail System Act can be jurisdictional for a parcel of land that does not itself contain any segment of the trail's tread. And we believe that that's a proposition that is relatively easy to prove is the case, that jurisdiction can apply to parcels that are off-trail, as I'll refer to it from here on out, as opposed to on-trail parcels, which do contain
Can I just
trail.
ask you first the question I asked the other side? Is this federal land at all? It's land over which the federal government has a certain easement, but that's a different thing, is it not, than a federal land at all? Why does either department have any authority here?
So federal land, it sort of depends on which way you are understanding federal land. In terms of Section 28 of the Mineral Leasing Act, federal lands are defined to be lands of the United States, except those in the National Park System. And we would contend that this is lands in the National Park System, and so while we would argue that this easement does fit—
Is it really land at all?
It is land. The property interest held by the Department of Agriculture is an easement and not fee on the property.
I understand that part of it, but the actual, this is to preserve a view shed, is it not? Is it really land at all? Does it really involve land or just a view shed issue?
So it involves the way in which that land affects the view shed, Your Honor. And indeed, with these national scenic trails, a large amount of the terrain through which the trails go is held through easements. I mean, when trails are going through land that is owned by the federal government, such as perhaps through a national forest, In that case, certainly the land is held in fee, but in a lot of other cases, even not for the viewshed, even just for the trail itself, what's held is a right-of-way. What's held is not property in fee. And so we would contend that the fact that the Department of Agriculture doesn't own the property in fee does not pose a barrier for there being, we would argue not federal lands in terms of the definition in the statute.
So what you're saying is that what is being condemned in a certain sense is two things here. One is the physical underground place where the pipeline is going to be, but because this requires tearing down trees and so on, it would affect the scenic easement itself. That's part of what's being condemned, and that counts as federal land.
Your Honor, we are actually not asserting anything necessarily in particular about the policy judgments of the.
I'm sorry, a policy judge. I'm just trying to understand whether this counts as federal land. Not given, and the definition is a little circular, right? Federal land is federal land, except for the parks. Okay, well, I get the part about parks, and I understand your argument there, but I'm just trying to get at the whole thing of federal, what makes this a federal land when it's an easement. But I think you've sort of said something about that, and maybe you can just go on then to the agriculture versus interior specifically.
Absolutely, Your Honor. So first of all, the issues of whether it would be the Secretary of Agriculture or the Secretary of Interior who would have the authority to grant this right of way are at outset not involved, because Section 28 of the Mineral Leasing Act poses an absolute bar on the granting of right-of-ways for pipelines going across lands in the national park system. And so it wouldn't even matter if it was the Secretary of Interior who had the authority to do that. There's an absolute bar placed. But nonetheless, even fitting this situation within the scheme of administrators as opposed to managers within the national trail system, it can be seen that it is the duty of administrators, which in this case would be the Secretary of Interior through the National Park Service, that have the authority to grant easements or right-of-ways across national scenic trails per Section 9 of the National Scenic Trail System Act. And there are really two inferences that I'll draw from Section 9 to demonstrate that that is the case. The first of those inferences is that Section 9 says that the Secretary of Interior or Secretary of Agriculture, as the case may be, may grant rights-of-ways across or along national scenic trails. Now, the issue here is that there are managers of national scenic trail property that are not within those two departments. So the administrators of National Scenic Trails are exclusively limited to the National Forest Service and the National Park Service. Whereas if we look to a 2017 Memorandum of Understanding for the Interagency National Trails Task Group, they identified a list of federal agencies that are managers in some capacity of any of the National Scenic Trails. And indeed, in that manager list, there are federal agencies such as, actually, the U.S. Army Corps of Engineers that are managers of some section of National Scenic Trails. And thus, because there are managers that fall outside of the domain of those two federal agencies identified in statute, we can draw an inference that it's the administrator that has the power to issue those rights-of-ways and not trail managers. And again, to be clear here, managers are federal agencies that manage some portion of land that's along a trail's corridor. There almost always are, many managers on a trail. Whereas there is a single administrator prescribed to each trail in the enacting language of that trail statute. And so based upon that inference, we'd conclude that there is an absolute bar and that even if there wasn't, it would be Interior's duty. Please overturn the district court. Thank you.
Thank you very much. Counsel for Mammoth has reserved some time for rebuttal.
Just two brief points on rebuttal, Your Honors. First, the second issue. Opposing counsel is correct that Section 325.8b does delegate certain duties from the district engineer to other authorities. However, Section 401 certifications are not included in those delegations. Section 404 certifications may be, but we are not dealing with a Section 404 certification here. And to the fourth issue, and to your question, Judge Trumbull, this is not land in question. This is an easement. It is an interest, a non-possessory interest that is held by the Department of Agriculture. And further, on page 9 of the record, paragraph 2, it also indicates that this is not National Trail Park land. This is not part of the national park. So there is no reason for the Secretary of Interior to have jurisdiction. And it is for those reasons, and others mentioned earlier, that we ask that you find in Mammoth's favor on all four issues today. Thank you, Your Honors.
Thank you.
Thank you very much. The matter is deemed fully submitted, and we will take it under advisement. Since that's the only case on our calendar today, court is adjourned.
Was a really great oral argument. So that was amazing, teams. Thank you. Also, I want to apologize because I pulled a Steve Harvey. It was Martha arguing, not Audra. So sorry, Martha. You were really great. So we're just going to have the judges deliberate, and when they come out, announce their final decision. We will present the awards, and then we can party it up in the event hall at the reception. So thank you.
So you were on brief this morning, and you were on when I saw you were on brief now. So you were both on brief here because they won the coin toss and you were on brief as a side. So I reviewed it when I was in law school, so I realized that the primary rounds against their rounds were both on brief and off brief, right? But when you got to elimination, the coin flip, and it just turned out that it was just a coin flip result. You both beat one in terms of and you guys did remarkable job. I was just all the way around. Your part and the red part and the blue part. It was a pleasure to see. Great job. Great job. I saw both of y'all this morning, and they were on brief here as well as it turned out. And that was terrific because basically, you guys did a very, very good extraordinary call taking close. And I will say something. I thought this one was much dead even. I forgot.
would definitely like it here. It is. I mean, the similarities are very clear, and when I love Chapel Hill, but I was like, okay, this is definitely at least as nice as Chapel Hill, perhaps even nicer since I'm not in the house nearby. But in the event, but that was just a terrific job on both parts, and I was really impressed with Judge. I mean, he's a famous judge for a reason, but I was like, man, you're really digging into him and finding exactly the questions that need to be asked. No. I just report, and again, both of you. I mean, I was just really impressed with all of you did a wonderful job of kind of coming back with answers to questions, making the code, and getting a little levity now and then in terms of playing off his jokes and saying, yeah, well, I mean, it was just extraordinarily poised performance on both your parts. So it was really an honor to witness. So whichever. Well, it's fun to. I mean, I'm back to it. I figured that out. But really cool. And people say this when they don't mean it, but I do mean this is truly one where it's sad that there has to be a error. And however this turns out, you guys should be extraordinarily proud of yourself. Thank you for your time. Oh yeah. I mean, they are super. They are super. So I think I mean I was involved in the earlier round because most of my classes were Thursday and Friday, but this morning I thought it was clear to me that we picked the right team for the entire group. I was sure about that, and when I heard it, it's like, yeah, those are probably good. And then after watching this, it's like I can't imagine that these were not the two best teams. If there's any, there can't have been any weaknesses better than these two teams. And so, anyway, good job, Howard. Oh yeah. Please be seated. Well, we are here to render a decision. Fortunately, we don't have to render a decision on the merits of these incredibly complicated cases. And I think we are unanimous in conveying our admiration of all four advocates, first just for the mastery of this material. When I first got this problem, I was thinking, this is supposed to be something where I can do this on a weekend.
Yeah.
And to try to develop sufficient knowledge even to understand the arguments was very demanding. And then, of course, the other advantage we have is this is the only one of these that we are judging, and you folks have been through round after round of competition. So our admiration for mastery of the material is universal for all of you. And similarly, we have to commend each of you for very formidable presentations in terms of the style of presentation. One of the things that we pondered was that I don't know enough about energy law to say absolutely who had the harder job on the merits, but we certainly gave the Mammoth team a harder time, which may indicate that there were more questions or whatever that occurred to us to ask, but certainly you had a lot of incoming fire and handled it with aplomb, and we have a great deal of admiration for that. And to the extent the degree of difficulty comes into play, we thought that was a significant factor. And we did not have an easy time coming to a decision. We didn't spend a lot of time in there, as you know, but we, you know, some of the things we discussed were, are we allowed to flip a coin? And we decided that if juries can't, neither can we. And in the end, by a divided vote, we decided that the winners are Team 20. And I think one of the reasons why the decision was hard is that we thought that you gentlemen made very smooth and effective presentations, and that's part of the problem with degree of difficulty. We may have given the other side a harder time, and we tried to think about how much we could factor that in. But I think that if there was a deciding factor in this, I think most of us felt that the oral argument is not a debate. And we thought, or the majority thought, that Team 20 were more conversational in their approach, invited questions, if they didn't get as many, responded to the questions sort of as you would to somebody who was asking you about the case, and not so much with an edge of maybe some adversarialness toward the bench. In saying that, I do want to particularly acknowledge the effectiveness of the rebuttal by Ms. Amdahl. I thought that was a particularly great performance because you understood what needed to be done. Now, I don't know that getting the last word necessarily wins a case ever in particular, but I think our view unanimously was that after a very long argument with lots of different issues, which is one of the problems here, you focused in on a couple of things where you had something specific and important to say that was in particular response to what had been raised. You made your points and you were done. And that's a very difficult thing to do. And, you know, it may be the best 2 minutes of anything that if you broke down each 2-minute segment, that was maybe the best 2 minutes. So it was a very difficult decision for us, and I just congratulate you all. It was, I don't think I've ever been involved in a moot court that had more difficult issues than this one. And the research capacity that all of you demonstrated, the command of the material, and the just ability to present things in an effective way was absolutely admirable, and you all have outstanding careers ahead of you as advocates, I'm sure. So that's our decision.
We should walk down and talk.
Oh, absolutely. Yeah, I think they want
Well, they're going to do a
pictures.
presentation.
Yes.
So they,
I think I'll just leave that there.
Oh, thank you so much. That was very fun. Thank you, sir. We really appreciate your time. Thank you so much, sir. Really appreciate it. You got it right. We're getting it right all weekend. Thank you so much, Judge. Thank you so much, sir. Really appreciate it. Those two things are.
So real briefly, on behalf of the law firm of Babs Callen, which has been a great supporter of this program for the last several years, they provide the prize money for the winning teams. On the behalf of the law firm of Babs Callen, presenting the first place plaque to Team 20 from the University of Virginia.
And congratulations to our runner-up, Team 5 from the University of North Dakota. And last but most certainly not least, we have a gift for each one of our judges because we definitely couldn't do this competition without you. It's very hard to recruit so many judges for so many rounds, especially for the final round, to have them come from all over the state. Judge Lynch isn't even from the state, and he came to our little West Virginia competition. So we're very grateful, and we're very glad that you're here today. So thank you for being such a wonderful bench. And now, if everyone wants to go to the reception in the event hall, which is out these doors and just to your right. Thank you, everyone.